Okay, well, hello everyone. Thank you for attending today's presentation on loan modifications held by the LA County Bar Association Real Properties Finance subsection. Our speakers today are Toby Pinsky and Catherine McCarthy. Toby is a partner at Seyfarth Shaw and Catherine is counsel at Mayor Brown. Just a couple housekeeping. If anyone has questions regarding today's presentation, please feel free to send an email to the speakers after the program. Thank you to Toby and Catherine for taking the time to present today, and I look forward to hearing what you have to say. And on that note, I will hand the floor over to Toby and Catherine.
Okay. Can we skip next slide to the next slide? There we go. So we're going to talk about loan modifications today, and given the environment, we're kind of going to focus on loan modifications in a context where there's a problem. The loan is in distress. There we go. Okay. The biggest picture things that the lender is going to look at is in terms of figuring out what their objectives are. Is this a bad property or is it a bad borrower? Is this a borrower that I want to enter into a modification with and work things out because I feel like I'm better off having this borrower manage this property? Or do I really think the borrower is mismanaging this or doing things that are not kosher? And do I need to get the property away from them? Because if the lender is thinking the loan is in distress and I don't want this borrower running this property anymore, they don't have an incentive to modify. The other thing the lender needs to ask, because there are all variety of lenders out there, is, am I prepared to take over this property? There are some lenders that are fully well equipped to take over a construction project half done, get people in place to finish it. And there are some who are not. And so they have to really be considering those things when they're thinking about their objectives in a distressed loan situation.
And from a borrower perspective, the borrower is going to want to consider what their particular challenges are, whether it's related to that particular borrower or related to the property. And they're going to want to sort of have in their head what they really need from the lender to make the situation workable. So are they going to need additional funds? You know, maybe they need to get some increased leasing action going on at the property and they want funds for TIs and LCs. Maybe they just need some additional time for performance of existing covenants under the loan documents. And maybe they really just need some permission to take additional actions that may be outside the loan documents, or maybe with respect to leasing where they might need the lender's permission. So they want to keep all of those things in mind when you start thinking about the possibility of having a loan modification. Greta, can you skip to the next slide, please?
So one of the things, the lender is going to want to do, and I think the borrower as well, is just put together a team of people that they anticipate having involved in the project. Oftentimes, as lenders counsel, we're consulting with litigators, we're consulting with bankruptcy folks, and so it's helpful to sort of know who your go-to people are for this particular deal, should you have questions that arise where you might want advice in those areas.
And this is also really going to help you as you start your review of the loan documents and the loan file. And this is something that both borrowers and lenders need to pay particular attention to. So a borrower is going to want to understand what the existing defaults are and what the lender's remedies are in the event there is a default. But they're also going to want to fully look at what their obligations are under the loan document. So they want to know if they're in compliance with the existing operating covenants and cash management, whether they have DSCR tests or debt yield tests, and what happens if they don't comply with those. Is it a cash sweep? Could this trigger an event of default? At what point can the lender really get involved without needing to consult with the borrower? To the extent there's construction going on at the project, if it's a construction loan or just possibly maybe some tenant improvements going on, they want to know, the borrower's going to want to make sure they fully understand what the status is of that construction and what the obligations are. Are there certain time periods that they have to hit in order to affect the lender's funding obligations? And these could be current funding obligations, or they could be future funding obligations. So what happens if these time periods are missed? And could that trigger a ripple effect where the lender might not need to fund future advances, and maybe the lender could avoid extension of the loan and the maturity date? They also want to understand, are there either existing mechanics liens or the possibility of mechanics liens? So if there's concern that the lender isn't going to fund a construction draw, how are they going to pay for the work that's been done at the project? And what do they need to do to work with the lender to make that happen? Also, what kind of notices might they need to give to the lender with respect to force majeure? And when does the clock start ticking? Does it start ticking at the time of a notice, or does it start ticking at the actual time of an event? They're going to want to look at the various reserves in terms of both funding and availability. And for borrowers in particular, they're going to want to understand what happens under guarantees and what the risk is with respect to a lender calling a guarantee. Are there any recourse carve-outs that may have been tripped, either during discussions with the lender or just generally as things are becoming more problematic at the property? So it's important to fully understand whether the existing guarantees are maybe for completion with construction, whether they're full recourse or related to particular carve-outs, whether there's any limitations, or whether maybe an upstream entity has given a carry guarantee if the lender had some concerns about cash flow at the property when the loan was entered into.
Lenders will be looking at a lot of those same things also. And one aspect of those things that as a lender's counsel, you need to be really aware of is whether there's a particular course of dealing that has varied from what the loan documents require, such that the borrower sort of feels like that's now what's acceptable. One great example is if they're supposed to be reserving tax and insurance impounds with the lender and they haven't been, and the lender hasn't made a big stink about that. So those are the kinds of things that you want to start becoming aware of at this point in the process, so that you sort of know where your client's risks are, and also their rights under the documents based on the facts as they exist. Another thing that's a little more lender specific is if there's a capital stack, and we're not going to spend a lot of time on that in this particular presentation because we felt like there was enough else to cover, but you definitely, as a lender, if you're in a capital stack, you need to be aware of what the other lender's rights and remedies are, when you have to give notices, all of those kinds of things, and when you can act without the consent of another lender and when you need it. And you really need to follow those rules to a T, because otherwise you're going to end up not just in trouble with your borrower, in a bad situation with your borrower, but also vis-a-vis the other lenders in the stack. Can we go? Yeah, thank you.
So the borrower is also going to want to look really fully at the loan documents and the loan file to evaluate their leverage. And usually the lender has more leverage in a negotiation for a loan modification, but the borrower can turn the tables if they find particular defects in the loan documents. And this can give rise, to increased negotiation power, because there might be issues in the documents that need to be corrected in order to make the lender be in a better place than they were initially. So some things that they might be able to find are things like original promissory notes not being delivered. Perhaps the lender agreed to close on a PDF. It's relatively rare, but maybe they agreed to close on a PDF and the original never got delivered, or to the extent there's a mezzanine loan, the borrower never delivered an original certificate of membership interest. If the loan documents call for cash management, you're going to want to look to see if the cash management accounts were set up, whether a DACA is in place, and whether the cash management agreement were actually executed and delivered to all of the parties. if there were post-closing agreements made in order to get the loan closed, you're going to want to review the post-closing agreement or the loan agreement that addresses these particular actions. And to the extent there were material obligations, were those actually fulfilled? If they were not fulfilled, why didn't the lender come back and say, hey, you were supposed to have filed these UCCs and you never took care of it, or you were supposed to have terminated old ones that, you know, stood in our way and those are still existing. So you're going to want to examine all of those things to evaluate whether or not the borrower might have some additional leverage. Also, to the extent there were prior modifications, did the guarantors ratify those? Sometimes they do, sometimes it gets missed, and that would be a good argument in favor of the borrower. You're going to want to look for inconsistencies in the loan documents, especially with respect to the default and remedy provisions. And it's important to review not only the loan agreement, but all of the documents, all the ancillaries and all of the recordables. You're going to want to look for missing signatures from the documents generally, and also to make sure that the correct party signed the documents. I actually recently worked on a transaction where the borrower did not sign the promissory note or the mortgage. Those documents were signed by an individual who was related but was not the borrower. They did not own the property. And when the deal went into default, the borrower was able to sue to quiet title because there was a mortgage on the property that was put in place by someone who didn't own it. So you're going to also want to look for unrecorded documents. It's pretty rare, but especially now in times of COVID where recording offices are closed, if there's a mortgage or deed of trust that wasn't recorded, you're going to want to know. And the same is true for UCCs. Were these actually filed with the relevant offices? Next slide, please. So it's important to review the entire file. And as Catherine mentioned earlier, from a borrower perspective, you want to look for evidence of course of dealing. You want to look for things that give rise to defenses, where the lender may have made admissions or promises or assurances that they were going to help or do something that is outside the loan document. So things like oral agreements can demonstrate a course of dealing and give rise to a detrimental reliance argument by the borrower. The other thing that is good to look for is just things that are common defenses to enforcement actions. The number one defense is a statute of limitations argument. So to the extent the lender accelerated the loan, but then never took action and never withdrew their acceleration, the statute of limitations may be running. And so the borrower may be able to make that kind of argument. Also, to the extent the borrower has been funding partial payments of the loan, and the lender tells the borrower they reject the payments, did the lender actually return those payments, or are they holding on to them? Next slide. Catherine, you're on mute.
Sorry. From a lender's perspective, there are some big picture things that can impact the leverage. One depends on who the lender is and who the borrower is. If you have a balance sheet client and this is a significant customer of theirs, they're going to be more inclined to want to work with this borrower, make concessions that they might not otherwise be willing to make, just to maintain the relationship. And also because quite often those particular borrowers are the types of borrowers that they want to keep in a property. They also may be more inclined to yield or work with a borrower if they know that they can't take the property over. That's just not a good option for this lender. They need the borrower to stay in there, then they need to work with the borrower to find a way that both parties can move forward with the loan in place, or that allows the borrower to work out a refinance with somebody else and get this lender out. Another time when lenders aren't as quick to push aggressively on enforcement is where they have a default, but it's non-monetary. The easiest kind of default for a lender to use as a basis for loan acceleration is a payment default, because typically a default needs to be material under the loan documents, or it won't be, or it's subject to challenge. So a monetary default, particularly on something like a monthly payment or a significant payment that was due, is a very easy thing to point to and say, this is objective, it didn't happen, the borrower's in default, this is material. The further away you get from that, the more you become subject to challenge that maybe the default wasn't something that was material enough to warrant acceleration of the loan. Think about all of the times where your documents say that the borrower is going to use reasonable efforts to do something, or that the lender is going to reasonably require something. That gets a lot harder to base a default and an acceleration on a default like that, because it's just much more of a fuzzy concept. So the more clear-cut and material the default is, the more leverage the lender is going to have in that situation. And then, of course, there's the course of dealing argument. If the lender feels that they're potentially subject to a challenge because they've been allowing the borrower to do something all along, they're going to be in a slightly weaker position on those issues because it's established a course of dealing between them and the borrower. And so that's the kind of thing that you really want to be aware of and look out for. And in your documents, which we'll get to a bit later, the contents of the documents, but that's the kind of thing you may want to address so that you have a clear path going forward about how things are expected to work. Things that decrease a borrower's leverage, obviously if you have a really good guarantee that's on point, especially a payment guarantee, or if the issue at hand is something that there's a really clear carve-out liability for, that really increases the lender's leverage even more than it is already, because you've got somebody that you can get to pay for the problem. If there's a monetary default, as we already discussed, it's pretty clear cut. That makes a great case for a lender to accelerate a loan. Or if the borrower's situation is contrary to general market conditions. So, right now you're seeing a lot of discussion between borrowers and lenders because there's this global situation that's going on that everybody understands. But if you had a great market and a borrower who was not doing well, that doesn't look as good for the borrower. That's more likely to be the kind of situation where the borrower's not going to have a lot of leverage. The lender may want to get them out of there. And that's going to reduce the borrower's leverage in terms of trying to negotiate a modification. Next slide, please. There are a few more things to be aware of sort of at the outset and to start thinking about. One is state-specific law where your property is. If it's not your state of practice, it's a really good idea to be consulting with local counsel. I say this from the perspective of somebody who practices in California, and we probably have some of the rules that people get wrong the most often. So we're particularly sensitive to that. In California, you have your one action anti-deficiency type rules. There are also other states that have some of those rules that you need to be aware of. And other types of things that are restrictions on lender or special rules that they have that you just need to be aware of in starting to put together the pieces of your modification. There are also borrower rights, in state-specific borrower rights that you may need to be aware of in the state where your property is. In California, for example, we have issues with redemption and reinstatement, and you need to be aware what the borrower's rights are should those things come into play. Additional bankruptcy considerations include, so here we are in the modification, we're starting to think about what's going to happen next. So bankruptcy comes to mind. And while you may have borrower bankruptcy covenants against doing things that will put the borrower into bankruptcy, covenants against filing, they may not all be enforceable, but you may also have, hopefully you have, recourse carve-outs that have been guaranteed, and you may be able to get to the guarantor in that situation. So those are things to be assessing and be aware of. This is also a time where it's helpful to be consulting with your bankruptcy counsel, as we talked about earlier. Maybe you have security interests that the lender agreed not to perfect at the time, but for bankruptcy reasons, bankruptcy concerns, you now want to go back and make sure those get perfected as part of your modification. But this is where your team is helpful because you can consult with those people about some of these things and things that you need to be thinking about and looking out for. And as a lender, sometimes you're looking at how, is there a way to improve my position a little bit as part of this modification, because this property is now a bigger risk than I had previously anticipated.
So next we're gonna move on to talking about pre-negotiation agreements. And pre-negotiation agreements pretty much set the stage for what's gonna come next, which is the modification. A pre-negotiation agreement confirms essentially that there's no obligation to actually enter into a modification by either party, by the borrower or by the lender. And it really just sets up a framework for the purposes of negotiation. One of the key points of pre-negotiation agreements are that they preclude any negotiations or statements made during negotiation from being binding on either party, and also from being entered into evidence during an enforcement action. So from a borrower's perspective, it really allows the borrower to be more upfront about what is going on with the borrower itself and what is going on with the property. So for instance, if there's not enough cash flow at the property for the borrower to pay all of its expenses and pay all of the debt service, the borrower is going to want to tell the lender this information, but it's also going to want to avoid an admission of failing to pay its debts as they come due, which is likely a negative covenant under the loan document. So by entering into a pre-negotiation agreement, the agreement will pick up often statements that were made previously and also statements made in the future, and the borrower will be assured that those statements won't be used against it to the extent the negotiation goes badly.
Oh, can we go back? Thank you. The other thing we wanted to say about pre-negotiation agreements is that this is not the modification document itself. You don't need to put every single thing in there that you hope to achieve in the modification. There are situations where a lender will require a release in order to enter into the modification discussions. That's going to depend on the lender's leverage in that situation, and sometimes on their policies and their relationships with a borrower. But in general, when the project is in distress, the legal cost matters. It matters to everybody, because the borrower obviously is having a hard time already. The lender is trying to figure out a way to keep this borrower functional and in its and in compliance with the loan moving forward. So they're not interested in siphoning off, a ton of legal fees in this process. They really kind of want to they want to be protected, but they also want to be efficient. So this pre-negotiation agreement is not a document that needs to reiterate everything that you're hoping to do in the modification itself, but it should set up some basic protections so that the parties can talk without feeling like they've made their situation worse by having the conversation.
Next slide, please. So one other thing that the borrower is going to want to keep in mind as it starts its initial discussions with the lender is, as Catherine mentioned, how can we make sure our legal fees stay under control? This is going to depend somewhat on the complexity of the particular modification, but if it's a simple debt service deferral, the borrower should ask for the lender to cap its legal fees. It should also ask that the lender engage origination counsel. This will minimize the need for legal fees for the review of the original documents and perhaps the loan file, but it's also less likely that origination counsel will discover the defects in the documents that it drafted. So, and as we mentioned previously, defects in the documents can be helpful to borrowers. Next slide.
From a lender's position, one thing that's really important in the pre-negotiation agreement, as I mentioned, is you don't want to be in a worse situation for having had the negotiation than you would have been had you not had it. You want to be sure that you reserve all your rights as to defaults that exist or that may arise during those discussions. You don't want to take a chance that a borrower interprets you're willing to talk with them as meaning that everything is going to be, as an insurance, that everything is going to be fine. We're going to work this out for sure. And we don't need to worry about these defaults because it's just all going to get taken care of in the modification. At the time of the pre-negotiation agreement, the parties still don't know how things are going to play out. So you need to be careful that you're reserving your rights in the event that things don't work out and you don't resolve everything in the modification, because you don't want those interpretations to, you don't want the borrower to have those kinds of interpretations of the situation. On the same point, as Toby mentioned about who's representing lender, I agree that if originating counsel is doing the modification, it is less likely that defects may be discovered. And I would suggest that even if you are originating counsel, there are some things that you should circle back at and just double check. Those special deals that are particularly complicated, particularly in California, include deals that have multiple borrowers or accommodation security interests. We see a lot of mistakes get made on those deals. If you have multiple parties that are co-borrowers, those are guarantors of each other. If you have somebody giving an accommodation security interest, even if they didn't sign a document that's called a guarantee, you need guarantee waivers for those parties, from those parties. You need to look at how your security is structured so that you don't anticipate having one action issues when you move forward. Some of the basic things that should be checked are what is secured, does the loan documents give me the right to accelerate the loan upon an event of default? Can I foreclose? Just some of those basic things, because it's pretty impressive sometimes when you look at, even though many of the big lenders have their own forms, they're not all perfect. And some of them have little defects in them. And you want to be sure that those basic things are done right. And it's worth a double check, even if it was your deal, or maybe you have someone else look at it for those things with fresh eyes. But those are the kinds of things that really need to be looked at regardless of who's representing lender, because if you miss something like that at this point, this is your chance to fix it. So if you miss it on this at this time, you've got a loan that's already in trouble, and now you've got potential problems going forward with it. Fee considerations. This is always a discussion in the modification space because all the parties are fee sensitive, as we talked about before. The borrower is already in distress. There's not extra money to go around here. You want to be sure that the pre-negotiation agreement says that the borrower is going to pay the lender's costs. One thing that some borrowers like to be particularly aggressive in negotiating, but one thing to be aware of is that that also affects their costs because extensive negotiations tend to take longer. And you need to think about the cost of diligence, because for a lender, you can't just rely on the diligence that was done at origination. There are things that need to be looked at new, or at least talked about with the client in terms of how to address them, just to make sure. And I think this is maybe the next slide. Yeah, we can go to the next slide. Because you need to make sure when a lender is entering into this modification, a lot of times they're starting with what the borrower has told them the situation is, but that may not be everything that shows the scope of whatever the problem is, or everything that shows potential trouble. And the lender needs to make sure that they really have a full understanding of the whole situation and not just what the borrower told them. So the scope of diligence that you're going to need to do will depend on the nature of your modification. If you're just doing a modification that extends a payment date for 30 days or defers for a couple of months, this may not trigger as many of these different diligence items. But in general, things you need to be thinking about are, should I run lien or litigation searches? And in the COVID era, you may need to consider what effects have closures had on filings and whether everything is really showing up on records. For financials, a lender will have a borrower's financials usually delivered periodically under the loan documents, but depending on how frequently they're delivered, they may or may not fully reflect what's going on. I was looking at the calendar, and you know, a lot of times when there is a quarterly that's due, it's often not due until 45 or 60 days after the end of the quarter. So that would mean that in early May, lenders hadn't necessarily gotten financials that showed the effects of COVID yet, because they wouldn't be getting them maybe for the first quarter until the middle of May. So you have to really think about what is the frequency with which those are coming in, and is what we have current. Title insurance. There is a difference between running a title search and getting a title endorsement. The title search is something the title company can do for you. It will ostensibly tell you if anything new has been recorded, but if they're wrong, you have no recourse for that. You have no recourse for an incorrect title search or inaccurate information in that regard, unless your client buys a title endorsement. Date downs, the type of endorsement that would update your title search and show you if something new has been recorded is a date down endorsement. They can be pretty expensive. They, in states where they are filed, they will be at a filed rate. In states where they're not filed, they can be as much as like a third of the original premium. Modification endorsements often have both a date down function and a function that incorporates the modification, that it amends the original deed of trust. There was an endorsement that was floated around that I was actually asked to talk about briefly, and it was a 110.5E, and it was an endorsement that was prepared specifically for COVID, and it had the title company ensuring certain, whether the modification had certain impacts or not. And I've been told by Fidelity that none of their companies are any longer permitted to issue that endorsement. So my sense is that that one's kind of going away, but it was out there for a little while. Another thing that you need to think about in terms of your assessment of the overall situation and your diligence is verifying that the parties that you're dealing with actually have the authority to act on behalf of the borrower, not unlike what you do at origination. And I'll skip to the end a bit, but sometimes some of these items can be shortcut by borrower representations and a strong carve-outs guarantor. So for example, what I would usually do to verify authority is maybe you get a resolution and you get a rep that the org docs haven't changed, and you have a carve-outs guarantor who's probably already on the hook for misrepresentation, material misrepresentation. So that might be the kind of thing that you can put together fairly cost effectively but still sort of cover that piece and make sure that you don't have a gap there in terms of your understanding of the situation. Modification opinions, whether or not lenders ask for those, usually depend on how significant a modification it is. A more involved modification, it becomes a lot more likely. And one thing to really think about in terms of a modification opinion is whether you're getting an opinion on, well, in addition to authority, whether you're getting an opinion on the modification documents, or whether you're getting an opinion on the loan documents as they have been modified by the modification documents. And I realize this could be a controversial point for borrowers' counsel, but my view is that the modification documents don't stand alone generally, unless you're amending and restating documents. They don't stand by themselves. You need to know that the documents as they've been amended work. And so my practice has always been, wherever possible, to get the opinion on the documents as they have been amended, because that collectively is the agreement that you have going forward. And that's the package that you need to know about.
Yeah. And Catherine and I have talked about this, and we definitely disagree here. And I think part of that is really dependent upon whether if you're serving as borrower's counsel, if you're just serving as counsel on the modification itself. Because if you didn't negotiate the original loan document on behalf of the borrower, you're going to be a lot more hesitant to give an opinion on documents that you didn't negotiate. And it's going to be a lot more costly for the borrower, because you're going to really have to review those documents and get comfortable with the enforcement. And also, it also depends on the age of the loan documents, because if the loan documents are older and maybe the law has changed since then, you want to be careful that there aren't things in documents that should have been updated that might not necessarily be all that relevant or harmful, but just aren't, but where counsel just isn't able to give an enforceability opinion because of changes in law. Next slide, please. So we're now going to jump into talking a little bit more about the modification itself. And from the borrower perspective, the first thing just to note, and this is regardless of the type of problem happening at the property, but the borrower is going to want to get in touch with the lender as soon as possible to alert them to a problem. The earlier they can get in touch with the lender to let them know what's going on and start the process, the more flexibility they may have and the more favorable the result. So the type of relief that they are going to request may be dependent upon whether it's a payment default or whether it's a covenant default. And with respect to payment default, the borrower is going to want to fully understand if the issue is related to a payment of principal and interest and the monthly debt service requirements, or whether or not maybe it's related to reserves. So the reserves under the loan may be a specific dollar amount, or they may be set by the lender. And there may be certain buckets that reserves go into, and the borrower may have the ability to move money sort of across the board, but they may not. So the borrower is asked to be related to moving funds from one reserve account to another, but they could also be related to just reducing payments into a particular reserve that might be overfunded. So for instance, if the taxes on a particular property are coming due and the reserve for taxes is overfunded and the borrower just simply doesn't have enough money to pay all of the operating expenses of the property and the debt service and the reserve, they might be able to approach the lender and say, you know what, lender, would you consider reducing my payment into my tax escrow for the next couple months, so that I can make sure that I'm going to continue to pay all of the operating expenses of the property. And so for instance, you know, if because of COVID, there were tenants at the property that weren't paying rent, but as things came back and started opening again, those tenants came back and did start paying rent, and the borrower knew that that was going to happen. The borrower has, you know, a cash stream that's coming in relatively short order, and they may be able to say to the lender, you know, you can delay this for a couple months because, you know what, you have adequate security for the payment of those taxes. We have a reserve account. It has plenty of money in it. It's really just a matter of tiding this over for a couple months until our tenants are paying in full again, and then we'll, you know, we can increase our reserve again and we'll build it back up and we'll all go on our merry way. But it's also important as the borrower is looking at issues of payment that it fully understands under the loan document what it is supposed to use the money it receives from rent for. So is the borrower supposed to cover all expenses first, or are they supposed to cover the debt service first? And it's common to have bad boy carve-outs under the loan documents, especially with respect to the payment of taxes and insurance. But oftentimes these might be limited to the extent that tenants pay their rent and cover those payments, or the guarantee might only be to the extent the borrower misappropriates funds that it was supposed to use for taxes and insurance. So it's important for the borrower to go back to the loan documents and understand the order of application of payment. And it's important to look, as borrower's counsel, at all of the documents, because the documents aren't always consistent. So the loan agreement might say, for instance, that debt service and all of the operating expenses are to be paid simultaneously. Well, that isn't really helpful because it doesn't tell you an order of payment. But the mortgage might have a more specific order. So the mortgage might say something like, first you pay the taxes, then you pay the insurance, then you pay the operating expenses, and then you pay the debt service. Okay, so the borrower then knows that it's supposed to pay all of its operating expenses first, and if there's a shortfall, then, you know, the loan is going to take a slight hit, but it might be protected from that bad boy carve out because it's applied the money how it was supposed to. But it's also a good idea to look at the assignment of leases. And I've had a situation where that's what the mortgage said, but the assignment of leases and rent switched the order of debt service and operating expenses and didn't tell us which document governed over the other. So in that situation, the borrower has to be really careful not to trip that bad boy carve out and is going to want to get in touch with the lender to come to an agreement on the order of application of those payments. Bring that defect to the lender, get an understanding of what they're supposed to do, and protect themselves against a possible call under that guarantee. And one thing to think about, as the borrower is, if it's really a payment issue, can we just, can we enter into a forbearance agreement? Can we have a time period where we freeze all the obligations that are due and give the borrower a little breathing room and just get back on their feet? Or do we need to go the route of doing a full-blown modification? So next slide. To the extent you're looking at a covenant default, a modification generally makes more sense. These are going to be a little bit more specific, and a time period might not really solve the problem. So if you're dealing with construction at the property and a construction loan, you're going to want, like I mentioned earlier, you're going to want to really understand the time periods that are required. So is substantial completion required by a certain date? And, when we're working in the current environment where there have been various construction stoppages and where there's been a lot of supply chain issues and materials might not be delivered on time, do we really need to go to the lender and modify time periods for deliveries and to complete and to make sure that the lender is going to continue to fund so there's no mechanics liens? If we're dealing with operating covenants, where you have DSCR testing, you're going to want to really think about timing. So is it feasible to keep the current schedule for testing, or does the borrower want to modify it for more frequent testing based either on what expenses are coming due or need to be paid currently, or to the extent they've tripped the cash management to really try to capture turnaround in as quick a manner as possible so that the borrower can get more control over their cash and go back to operating the property in the manner that they had been doing previously. And some of this is really going to depend on, as Catherine mentioned earlier, like, are we dealing with a bad property or are we dealing with a bad borrower? If there's no evidence of being a bad borrower, and thus far the borrower has been operating the property, in a great manner, and they really just fell on hard times due to COVID, then it's going to be a lot easier to get control of that cash in a faster way than to the extent there's evidence of larger problems at hand. And lastly, the borrower's going to want to consider whether they took any actions that they shouldn't have without the lender's consent. So the borrower may have agreed to permit a tenant to forbear on its rent. Retail has been closed and the tenant isn't having any income and therefore can't pay its rent, and the borrower may have said, well, it's okay for now, we're gonna work with you, and they didn't accept their rent, or they may have actually modified the lease to extend the term and amortize free rent over a longer period of time, but they didn't go to the lender and get the lender's permission. So it's important to understand if they were supposed to have done so and if they gave the lender adequate notice. And they're going to want to work that into the modification. But there's also another scenario that I wanted to bring to everyone's attention, which is pretty COVID specific. With tenants receiving PPP loans, it's possible that tenants are coming to their landlord to say, we want to prepay our rent. And a lot of loan documents don't permit that. They'll have specific restrictions on borrowers making payments more than 30 days in advance, or a certain percentage of borrowers making payments more than 30 days in advance, because the lender wants to make sure that those funds are available in real time for application to debt service payments. And so to the extent a borrower is faced with a tenant at the property saying, we want to take our PPP money, we want to make sure to pay you in advance because we want you to get paid, landlord, then that landlord needs to turn around and approach the lender and get permission, and oftentimes. So, and the lender might take action such as escrowing funds. It really depends on how large those payments are, and how well the property is doing despite the downturn. So in these scenarios, you're probably looking more at a larger modification type document. But again, it really depends on the circumstance.
Yeah. And just to follow on what you were talking about with the COVID prepayment potential, in addition to just the money being available for debt service going forward, the other thing a lender's worried about is if this tenant has prepaid for 6 months and I foreclose in month 2 or 3, now this tenant is living rent-free for the next 3 months. I can't collect any income from this property because they've already paid it, and presumably if the borrower had it and I'm still foreclosing, that money is gone, long gone. So that's another sort of the flip side of that issue is the money needs to be available in the lender's mind on a monthly basis, whether it's to pay debt service or for property expenses after a lender forecloses. So obviously the first and one of the primary business issues that the lender is going to deal with in a modification is responding to what the borrower is asking for. What is the borrower saying that it needs to make the situation workable? And usually if the lender is going to consent to that, there will be conditions that are imposed on it, maybe financial tests, maybe cash management, maybe escrows, but they're going to be saying, okay, this is what you need, and how do I then get comfortable with it? And a lot of that is going to come from the business folks, most commonly. So that's the kind of thing that they'll be feeding to you in terms of what their business decision is about what they need. Another thing that a lender will be looking at, and a borrower, quite frankly, because I have some deals where this is the case right now, is we have this situation, but there's also a maturity date coming up, and it's not that far away. And what's going to happen when the loan matures? Because under the current circumstances, the borrower is not going to qualify for an extension. Either they haven't been making payments, they don't have the right they aren't going to qualify under the financial tests. Maybe there's an LTV problem. If we thought, for example, that construction was going to be to a certain point and it isn't because of what's happened. So an upcoming maturity date is also something that a lender is going to be really focused on in terms of what's going to happen when that maturity date hits, because the lenders, for the most part, rely on the borrower being able to finance them out, or the loan being extended, or maybe they're going to do a new loan with the borrower. And so where that's something that's quickly approaching, it's something that the parties need to be talking about and not necessarily punting down the line too far when they're talking about resolving the current situation. Another big thing that obviously a lender is going to think about is that maybe this modification isn't going to work. We're going to try this, we're going to enter into this agreement with the borrower, but we may still be in a bankruptcy situation in 90 days, or we may still end up needing to declare a default. And what is our current situation? Is there anything that I need to do to get myself ready for that? And like I mentioned earlier, sometimes, occasionally, a lender will agree to take a security interest in something but not perfect it. Maybe perfection of that security interest becomes a condition to this modification. That usually applies when it's some sort of ancillary piece of collateral, but I have seen that from time to time. They need to be checking their UCCs, like we talked about earlier. Is everything filed and recorded the way that it's supposed to be? And they need to be sometimes looking at the borrower structure. If you have a big one of those portfolios and you've got all these little borrowers that are related, talking to your bankruptcy folks about how this is all going to play out. Those are the kinds of things that a lender needs to be thinking about, and particularly in the event that there's some kind of adjustment that they can make in the modification as a requirement to helping the borrower. That will help prepare them in the event that things do continue to go sideways with the loan. Another possibility is that if there is no cash management in the deal, or if there is cash management, but for whatever reason, because of the way the triggers were set up at the outset, it hasn't necessarily been tripped, but it's just there waiting to be used. That is something that lenders quite frequently will implement to help themselves to feel more secure about the situation, to sort of protect against maybe that the borrower is not going to do things the way they would like for them to be done. And without really exercising a lot of control over the property, they can get a fair amount of control over the cash, or at least make sure they know where it's going. When you have cash management, if you're really going to do the full-blown cash management, you're going to have a discussion with the borrower about what operating expenses are going to be dispersed to them. Because in that scenario, you're collecting all the money and you're doling out operating expenses to the borrower. So that's always a conversation that you have to have, and it's something you have to be careful about as a lender, because you don't want to get too much in the borrower's business, but you also want to be sure that everything that the borrower doesn't really need, that you're putting through into your other buckets to make sure debt service get paid, tax and insurance and those other things. And quite often, the priority is tax, insurance, or debt service first, one of those two, and then the other. And then I think operating expenses, and then sometimes there's like an excess cash fund where maybe whatever cash is left over, you're going to sweep and apply to the loan. That's part of a lot of modifications in this kind of scenario. You want your borrower and your guarantor to reaffirm the reps and warranties that they made at loan origination. It's possible that because of the circumstances, there will have to be some exceptions to those. And I think that lenders generally understand that. But this, again, is part of making sure that as lender, you really understand the full scope of the situation and what's different now than the situation that existed at origination. Just making sure that there aren't other things going on that you haven't found out about yet that maybe are going to surprise you in a month or two. So that's a pretty good standard thing to be asking for in a modification. Another thing is, do you need to adjust how frequently financials are being delivered? In a situation like we have now, I think lenders generally are wanting that information faster, particularly if they didn't have monthly reporting prior to this situation, because the situation on the ground is changing quickly. Tenants are reopening, tenants are closing again, and they really need to have a current handle on what's going on with the property and see how all of those things are affecting the income stream. And if you've got a borrower that isn't required to deliver reports more frequently than, say, quarterly, and then it's, like I said before, it's often 45 days after the end of the quarter, there's a pretty big lag time there in a lender being able to see what's going on at the property, especially with things changing as quickly as they are. So that's something to think about. A lot of times the financial guys will get current financials, they'll ask for them in the context of doing the modification, but they really also need to be looking at, in the structure of the loan docs, do I need to change the frequency of that reporting going forward? And then another item is always the guarantee. A lot of loans have guarantees for recourse carve-outs, but unless they're construction loans, they often don't have a payment guarantee of any type. So that's picking up liability or losses that may occur because the borrower did something that is quote unquote bad, the bad boy carve outs. And that's picking up things like they made misrepresentations, or they made a transfer that they weren't supposed to make, or they committed waste at the property and things like that. But it's not helping you if there's just a payment problem necessarily. So some of what I've been seeing in the current environment is that maybe lenders are agreeing to defer payments for some period of months, but they're making the guarantor guarantee those payments so that they have that extra backstop that money is going to get paid at some point in the future. They don't feel like they're just guaranteeing it with no hope of getting it back ever. And that is giving them a little more comfort. You have to be careful with payment guarantees when they're not for the full loan amount, because you have to start thinking about, if the borrower makes a payment what part of the loan did it get paid to? If they're making a principal and interest payment, did it get is it part of what was guaranteed, or is it part of this other piece that is not guaranteed? So you have to be careful about those kinds of things. And if there's a small piece of the loan that's guaranteed and the rest is not guaranteed, if it's workable in the context of the deal, the right thing to do is to say that the guaranteed money is the last money that gets repaid. If it's a different situation, like I have one now where we've got payments that are being made each month, so that are excess cash is being applied to that deferred amount each month. So the guarantor's liability is legitimately reduced each month based on how much of that excess cash after payment of the regular interest is applied to that deferred amount. Then that really is, okay, that's the same bucket of money that the guarantor was guaranteeing. But in general, that's something that you really have to think about and be careful about. Okay, next slide. Releases are a really big deal for a lender in a modification. I think that it's natural for the business folks to get focused on what is the current problem, and we're solving the current problem, and then we're all going to be friends and move forward, and things are going to hopefully work out. What the lender really doesn't want to have happen is that they feel like they've made some material accommodation to the borrower, and then a month later, the borrower brings a claim for something that existed prior to the whole modification discussion. So this again is part of making sure that you really have a handle on everything that's out there and what the entire circumstance is at the time that you're agreeing to make accommodations for the borrower. In California, there's a special civil code 1542, which if you don't use a 1542 waiver, you're not deemed to have waived claims that you didn't know about yet. So what that would mean is, say a borrower claim arose in January of 2020, or the basis on which they could make a claim. And they don't know about it when they do a modification in April with the lender, but they find out about it in June. And now we've got essentially a situation where we didn't have a full handle on everything that was in play at the time that we did the modification. If the borrower has not waived unknown claims pursuant in accordance with 1542, the borrower still has that claim live. But if you have included a 1542 waiver, then what it does is it allows you to effectively waive claims that you don't know about yet. I think the valid releases are for claims that have occurred up to the modification or during the course of the modification. You can't get a waiver for things that haven't happened yet, but you really, that is something that you really need to focus on and be sure that you include on the lender's behalf. It's really important that the guarantors acknowledge the modification and reaffirm their guarantees. Guarantors have rights, and in California, they have a lot of rights. And if you have done things to the loan that affect their liability and they haven't consented to that, then they could have outs. So it's really important that every step of the way when you modify, that you have that guarantor signing on and saying, I've seen the modification, I consent to it. I reaffirm my obligations as this modification may have changed them. Those are all important concepts that the guarantor, and it doesn't have to be long, it can be, you know, a few sentences, a couple sentences, a short paragraph, but you really need to get that every step of the way when you're altering loan terms, because otherwise you run the risk of a guarantor having defenses against you in the future. Cleanup. This is something we talked a little bit about earlier, but you really need to have checked your documents on all the material points and make sure that there's no cleanup that you need to do that's going to have a big impact on the effectiveness of your documents should you need to enforce them in the future.
Sorry, Catherine, I just wanted to let you guys know that we are running up on our time, but There is no, it won't shut down right
Okay.
at the 1:30 mark. We just have a few more slides, so
Okay.
if you guys want to just, we can wrap up.
Okay, yeah.
Thank you.
So you need to make sure, as I mentioned earlier, that it's clear what is secured by your mortgage, deed of trust, your collateral documents, assignment of leases, cash management, grants of interest and accounts. You need to make sure that you know what's secured by those things. And you need to make sure that you can accelerate and foreclose if there's an event of default. The biggest thing that I see in California are guarantee issues. Most of the documents that I've seen that we did not originate that have multiple obligors, which means if they're co-borrowers, if they're responsible for the same things, they're basically guarantors of each other, and they ought to have guarantee waivers. And the other thing that I see in California a lot is guarantees that are inadvertently secured. In California, you don't want your guarantee to be secured. We have an anti-deficiency rule that says that if you non-judicially foreclose, then all of the debt that was secured by that obligation, you've gotten what you're going to get from it. You can't go back and pursue anyone on that debt anymore. So if you have a deed of trust that secures a guarantee, whether you meant to or not, and you non-judicially foreclose, that's now part of the anti-deficiency collection of things that you can't collect on. And specifically, the thing to really look out for is where I see it happen by mistake quite often is the secured obligations will be all of the obligations under the loan documents. And the loan documents definition includes the guarantee. So that's something just to be sure to double check because losing your guarantee is a pretty big deal. And that's something that you can clean up in a modification like this. Other things to look at are your remedies consistent across the documents. I think as Toby mentioned earlier, you might have one thing that says, if in an event of default, I can do X, Y, and Z, and over here, it's different. And when the language is inconsistent, particularly if there's some sort of order of priority that's inconsistent, that's a problem. And this is a time to clean that up. And then notice provisions. This might seem like a little thing, but if you've ever had to send a fax, a certified mailing, and a FedEx, and a UPS to multiple different addresses for the same parties because the documents were inconsistent as to how the notice would be sent. And in addition to that, the parties had changed address but never gave the formal notice that's required under the documents, which means you have to send it to the notice address that's in the documents to comply with the documents, and then you have to send it to the address where you know they really are. You'll know that this is a good time also to check your notice provisions and make sure you have everybody's addresses up to date. That's a non-controversial thing to fix in a modification, but it just can save you headaches later, and just that the delivery of notices is all provided for in a consistent way. Next slide.
And I'm going to jump in for just a second to piggyback off on that and probably make a point that's more lender favorable, but to the extent that the lender obtains, updated certified articles, it's important to check notice addresses there to make sure that the registered offices of the borrower are the actual offices where they really are practicing. Because to the extent you need to make an enforcement action and you have to give statutory notice, you're going to want to rely on that, and you want to make sure it's correct.
Okay, and this is just, I just wanted to show what the 1542 language looks like. So this is just an example. We don't really need to spend a lot of time on this. We can go to the next slide. Okay, what documents need to be modified? A lot of times parties will think, well, I'm just changing, we're changing a maturity date and, we're going to defer these payments and we're going to do a couple little things, but I don't need to record it, right? Things that you need to look at in terms of really looking at what documents need to be modified include things like, what is the definition of loan documents in your deed of trust? What is your definition of what's secured? Does it include amendments to those documents? If your deed of trust secures obligations under the loan agreement, but doesn't include any amendments to the loan agreement, and the definition of loan agreement doesn't include future amendments, and you're amending your loan agreement and it has things in it that you care about, you might need to modify your deed of trust because the definition doesn't work anymore. So those are some of the things to think about in terms of what needs to be modified, in addition to just, which documents terms am I fiddling with. Another consideration is, and this kind of gets more to a point closer to the bottom, but if you're changing your maturity date or you're changing a loan amount, maybe you're deferring some of these payments, these monthly payments, but you're adding them back into principal, interest payments that weren't paid. Does your deed of trust need to be modified? Because now you've got information on record that's not inaccurate, because now you've got a $120 million loan instead of a $117 million loan, and your deed of trust that's on record is only for $117 million. So those are some of the things to think about in terms of, and also, are you changing any information that you had on record that other third parties might be relying on in terms of trying to understand your loan when they look at record? What are you giving notice of when you have your document of record? And are you changing any of that information? And are you changing anything that the applicable jurisdiction requires to be on record? So those are some of the things to think about in terms of what documents need to be modified, whether it needs to be recorded. And then I'll just say a quick thing about amending versus amending and restating. I think Toby's right. One of these points on the slide is her point, is that from a borrower's perspective, if you're just deferring debt service for a short period of time, you could have a simple letter agreement. And when you get into more complicated amendments, the thing that you really need to think about is this going to be understandable to a judge if this ever had to get enforced? Is somebody or some other party, is somebody going to be able to pick this up and read these documents? Because when you get into those amendments where you've got 7 amendments, or you've got those amendments where you're deleting these 3 words on the 4th line of this paragraph and replacing them with this, and you're doing that in multiple places, it becomes very difficult to follow, for anybody to follow who wasn't the person who worked on the deal originally. And it's important that the documents be understandable. So there are times where it may just be better to amend and restate your document just to make it easier to follow. And frankly, there are times where amending and restating is even more efficient, because you've got most of your recitals, all the parties are in there, all your boilerplate. You just need to change a couple recitals and then change the terms that you're changing. So it's something to think about, that an amendment sometimes can be best done as an amendment and restatement, just for purposes of being able to understand it, and sometimes even for efficiency. Okay, I think that's it for that slide.
Oops, I think we may have lost our conclusion slide, but But we just wanted to circle back to just say, that it's really imperative that all the parties educate themselves on not only the deal terms from the existing loan documents, but really what is the real world business situation going on with the borrower and with the property. And what is the time period where that condition is likely to continue? And what relief is going to help resolve the situation at hand. So both the borrower and the lender really want the property and the borrower to keep operating and get the property back sort of on the positive side of the balance sheet. But it's important also to keep in mind that we're really dealing with the start of a potential enforcement action. Where the lender's going to want to make sure that it's protected, but the borrower's also going to want to understand, like, what are the consequences if the modification doesn't end up getting signed because the parties can't reach an agreement, or what if the modification gets signed and a couple months down the road, like, things just really aren't working. So as Catherine mentioned earlier, it's really imperative to consult with, your entire team, litigators, bankruptcy folks, the folks who worked on the original loan documents, and really understand the big picture here. So it's in everyone's best interest to document the modification as precisely and as specifically as possible, and just to be careful and try to work through everything together in the best way possible. But also remember that, it's possible that this is not going to fix the problem, and what's going to happen if that happens. So with that, I'm going to turn it back over to Greta for a couple parting words. Greta, I think you're on mute still.
Sorry, always happens. Thank you, Toby and Catherine, for a very wonderful, informative presentation. Just wanted to reiterate, if anyone has questions, please feel free to submit them by email to Toby and Catherine. Their email addresses are on one of the earlier slides in the presentation. And on behalf of LACWA's Real Property Finance subsection, thank you everyone for attending. I hope you've enjoyed the program, and I encourage you to consider becoming a member of LACWA and the Real Property section. We have 6 subsections, and each of them puts on about 5 to 6 programs a year. And we also hold networking events, so please check out lacwa.org for more information. And on that note, I think it's a wrap. Thank you again to all, and have a great day.